Come up, Mr. Jones.
Mr. Nayland is in Cancun until Monday next week, Judge, so he's not available this morning.
I understand.
So I'm kind of filling in. I have had a chance to look at this violation report regarding Miss Blows. I'm assuming that's our issue here today. Spoken with Mr. Jones about that. Pressed upon him the need for perfection here.
This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over. And there's absolutely no excuse for the missed blows. How many missed blows do we have?
That's 19, Your Honor. That's 7, within that 7 or 8. But Judge, I would ask, if possible, as I'm not the lead on this case, and I know Dustin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So
I'm sorry, Ben, I can't. I have to know. You have to know that we mean business. I'm not here to toy with you and play games with you. Know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, y'all. Cold weather. I apologize. So can I please speak on the breathalyzers?
No. You know what the expectation is. You have 19 missed tests. That's it. I'm sorry, Ben, I can't. You're here in his stead. You're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Oh, please, no.
No.
But to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate for alcohol.
I go to sleep early.
Test. And he is blowing outside the window, so we don't know what he's doing.
My God, sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock ones first thing in the morning, Your Honor.
Then you come here and you ask.
Oh, they just told me about this last week in pre-trial over there, and they said that I had a 45-day miss.
You have 19 missed blows, dude. Covering the camera.
Please, Honor. I will do anything. I'll even go on that drug, Ankle. I'll do anything, Your Honor. I'm really trying here. I swear to God, I will do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor. It's just, I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock and I still did the ones later on when I would wake up. And they told me this just last week, Your Honor. I swear to God. I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one
I started
pass after the other. He goes with you. No.
Oh my God.
Your Honor, may we discuss setting a new bond?
Of course.
Oh my gosh. Why? Please, I'm trying here. I'm trying to do everything.
Goes with you.
Oh my gosh.
Bond is at 5,001 now because of the prior violations. I will now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. He has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to view. It doesn't mean that there's.
It's the same thing. If we can't see you in the camera, then you're fooling. And I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, I've got it in black and white, and Dustin knows that it's no tolerance.
Consider 7502, Judge, for bond.
Okay, Ben. Okay, great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not gonna do that. I can't. But fine, because.
Visit PC, Your Honor. I have some questions.
Oh, you picked up a new case. I'm sorry, I'm just getting wind of this now. I didn't realize this. He just picked this up.
My client or the person?
Yeah, him. Picked up an interference 2 days ago.
That's what I'd like to revisit.
Yeah, of course. So you were on felony probation for a very serious case, evading arrest in a motor vehicle, which carries up to 10 years in prison. Now you've picked up a new case. Greg, I got to tell you that I don't know how much you know, but I have quite a bit of history with Mr. Zenon here. In fact, within the last 2.5 years, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now he's on his 10th case. Specifically, an unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, a felony possession of marijuana, felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for an evading. And now we have.
Right, but all those cases were dismissed, correct, Your Honor? Okay.
Pursuant to the, I guess,
I understand.
that we literally had one after the
Understand.
other, like a rung on a step ladder. One after the other.
And-
So let's do probable cause.
Thank you, Your Honor.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I just wanted to give you a heads up of how much history we have with Mr. Zenon, because it's a lot.
I appreciate that, Your Honor.
Sure.
But be that as it may,
I'm not going to hold, I've never will hold anything against him. So let's go.
On December 3rd of 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was
Observed what?
located. They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon.
But he has an open ag assault somewhere else too?
In Fort Bend County, Judge.
my understanding is it's
And
an
it was
older
open
case.
warrant at that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure. Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going blank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe,
So,
but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. And they're
I understand that.
a 0.1 mile away from the location.
So-
For what?
Well, okay, I get that. But so we have what we have. We've got a disturbance at HEB. Cops go there.
Okay.
They start to talk to him, and I guess at that point says, "Hey, man, I'm going to slap her." So at that point, I mean, that's what we have,
Okay.
right, Mr. Zenon? There's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else was there another warrant that you said?
It's the aggravated assault, but Judge, I also would like to point out that
But they end up putting him in the car. And at that point, he basically just goes plank like this for them being unable to effectuate an arrest.
And Judge,
I don't think that's an interference.
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it. Because, I mean, there's no better way. Let's read it.
Hold on.
I'll give you, All right. Let's pull up the code.
Intake could have taken some other things, but
Well, certainly they could have
Okay.
taken a whole myriad of, I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on, you know?
but they didn't
Hit.
They took the one that I do not believe applies here.
Let's read the code.
Okay.
Let's see what the code says. Because, you know, there's multiple ways that a charge can, you know, that you can charge someone with facts, right? There's multiple ways that can, it's 3815.
That's okay, don't worry.
You're right. It could have been like a resisting, you know, but. Okay, you ready? A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. Two, a person who is employed to provide emergency medical services, a firefighter. Number three, for an animal under supervision. No. So I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is. You
Okay,
agree
so
with-
the cop can claim anything is interfering with public duties. I mean, constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute, that's the penal code.
You'll find no argument with me, right? It is pretty vague.
Yeah.
It is.
He's got bigger issues. I mean, they should have taken the other charges, my whole point. I mean,
But he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
I mean, that's assuming they even had the right to do that. I mean, he's 0.1
It's an open
miles away.
felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay,
Please.
Judge. They were investigating the assault, Judge, is what the threat that he admitted to making. So it was an active investigation, and then when they were detaining him, he was resisting arrest, is what it seems like. And that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing. I
Mhm.
mean, that's what they were investigating.
And the witnesses all
They
described
put him,
the
I guess,
defendant.
did they put him under arrest at the time when he said that he was making that threat?
And with being
I mean,
0.1
did they
miles-
have the authority to arrest at that time? Right?
So I think it was during their investigation, the defendant admitted to threatening, that he would slap Miss Clark.
And it's at that point they start to put him under arrest?
At that point, they ran him through the NCIC and they found that there was an active warrant. And then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or
But
pushing.
remember,
That's
I
a
mean,
resist. That's not interference
could
with
be-
public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate with, which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. If the officer didn't put in the report, he's not saying in the dim summary, you are under arrest.
Well, I mean, it's
Okay, well, I mean, but so this
we
is,
don't know. I mean,
okay, I'm just saying.
if he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is,
We also don't have the offense report yet.
We don't
I
have
Judge.
don't
Judge,
care. I
he
mean,
was in
but
the
I think that
process.
there's enough, you know, he places him in custody, right? He's going to arrest him, starts putting him in the car, and dude goes plank.
I see, I know, but I don't have the.
I
I've
mean, I
shared the
think that-
videos with.
Remember,
You're right, I haven't had a chance.
Guys, this is a very low burden. This is probable cause. This is not beyond a reasonable doubt, you know? Beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you are disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way. Like you go over there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
Whisper to me because I want to know what you're about to say.
And if you want time, you guys can go back and talk.
Okay, well, I got to say.
Required 3 times to search me.
Can I have a moment to look at the video here? He's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can, I'll find it now. We can reapproach Monday morning or tomorrow even. And if you find, you know,
Because I
if
want
you
to
find a
out.
completely set of different facts than to what they're saying on video, I'm all ears. I'm always all ears. I'm always willing to rehear probable cause at any time. I mean, it's not the be all end all. But for now, what they're telling me, if it in fact is the case, there's enough for probable cause to go forward. Is there enough beyond a reasonable doubt? I don't know. But be that as it may, you know. Okay, it looks like they didn't give him a PR bond on this.
Okay, so well, then
The
address it.
bond right now is set at 2,500.
Okay,
Your bond upstairs is set at 5,000. Tell me about that Fort Bend case. Is it old? Is it new?
Let me check, Judge.
I think it's 2023.
Is it? I don't know. I mean, because it looks like you got on probation in October of this year. When you're on probation, dude, on felony probation, you have a freaking halo over your head. You know, you got to be as good as you can. You're facing a lot of time in prison. Have you been to prison before?
Sir. No, sir.
It's not a fun place, you know, and I don't know what we need to do to get your attention, man. In life, if you're with a person that brings the worst out in you, then don't be with that person. There's a gajillion and one fish in the sea, but how can a person get you so wrapped around your finger to make you, you know, just go. It's like a cancer. When you have cancer, if you don't cut it out, it kills you. This is killing you.
I can contact Fort Bend, Judge, and get more information.
Well, it doesn't matter. It's neither here nor there. I'll do whatever you want to do. You want to set tomorrow, Monday? What in?
I'll watch it today and come back tomorrow if you want.
Yeah, I mean, if you want, surely. Do you have it?
We have the camera, the body camera.
I just shared.
Okay, so
They shared it. They just shared it with me.
Yes.
let's roll it to tomorrow. You guys take a look at the video as well. Be prepared, and then we can reconvene tomorrow. For purposes of now, I'll find probable cause, and then we can regroup again tomorrow.
Okay, thank you.
Yeah. Okay. All right, Mrs. Zenon. See you tomorrow.
See you tomorrow. Yes, give me a second.
She sent me an email from one of
If
the.
anything, have you done for your GED?
And what I did for it,
What have you done?
I went to a class and then I tried to go yesterday. They canceled it and he also
You went the day before
That's, and I also went before.
Judge, she's been going. She's been going before even the last court date, and we you know,
Prove it.
I can text you.
In this life, you are only as good as the proof that you don't have. If you don't have proof, you have nothing. Spoken word means absolutely nothing.
Judge, the instructor, I have an email from him that she sent me saying that she's been going to the classes and that class was canceled on the 4th yesterday. But she did, you know, attempt to go to class. So she's been going. She did already take a test, and this is one where she did fail the first test. So she's been working on it. It's not enough.
I mean, here we are. How many resets have we had? We've had 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 resets since May. You're now in December. You have had 5 to 6 months. Show me the money. Otherwise, it's not going to go well for you today, Ms. Dixon. Show me. 5 to 6 months.
And Judge, this was a case where she was paying for the classes, and then she had to then enroll into the free program, which she's been doing for the last little bit.
Are you playing Candy Crush? What's going on over there?
No, I'm trying to text you.
Texting who?
The instructor. Like, what I'm supposed to show you? Because I don't have no proof. Like, I don't have nothing.
Tell me what have you done?
I went to the class.
Okay. Which class did you go
The
to?
GED resource.
Okay. And what, because the way I understand it, there are different modules that you do. You do science, you do language arts, you do math, you do, and whatever else it may be. You go through each section, you complete it, take a test, and then when you're done with everything, you take an overall test, and then you get a diploma.
That's not.
What have you done?
Basically explaining on how everything's going to go, and I was going to finish everything else Wednesday when I was going to go, but the class was canceled.
Who is the provider that you have?
His name is.
Grab me a phone number because I'd like to call them right now.
I have a number for you, Judge.
I'm going to put this on.
Charles Jackson.
Mr. Jackson? Yes, my name is David Fleischer. I'm a judge here in Harris County. And I have someone that's with me in our court, and she's doing a program with you guys to try to get a GED. I'd like to confirm that's Coriel Dixon. So Wednesday and Thursday, and then did you say every other Saturday? Okay. And then, so how does it work as far as getting the diploma? Do you do different classes as far as science, math, and how do you at the end get it? Can I put you, I have her in front of me. Can I put you on speakerphone so that she can hear this as well? Do you mind? Okay, hold on. So I've got him. Okay, Mr. Jackson?
Order in the court, please.
Okay, tell me, how goes it?
So, yeah, it's kind of twofold. They take an assessment. Based on that assessment, it allows me to know where the student is as far as their grade level in math and in reading. Based on that, they go on 2 tracks. And so one track is like a verification where we're just literally working on kind of some elementary reading and math skills.
Okay.
Or a GED track where they're ready for GED contests. And so, yeah, and I usually just, go from there. I work with my GED students individually. And
how long does the process take? And how long can we expect it?
Well, so that's honestly kind of a loaded question, depending on where they fall. I believe Coriel scored pretty well.
Great.
So yeah, and I've worked with people that have gotten the GED in 3 weeks. I've worked with people that have gotten the GED in 2 years.
I can't do 3 years. That's too much.
Well,
I know. I'm kidding.
No, I understand that.
She's been faithfully attending, though. Yay or nay?
Yes.
Okay. Great.
And with some consistency, 3 to 4 months, maybe less.
That sounds great.
That's just me ballparking.
I'd like to stick with it because I think at the end of the game, our goal here is that she ends with that diploma. And I think that would be a win for everybody. I'm calling you. I want to make sure that everything's going well, that she's faithfully attending and doing well. And it sounds like you're saying that this is what's been happening.
Yes.
Great. Okay. So I'm just going to continue everything. Just continue to go, Miss Dixon. I mean, you got, like what he's saying, if you continue at it 2 to 3 months, you'll end up with your diploma. Okay. All right. Thank you so much, Mr. Jackson. I really appreciate your help. You've been great.
No problem, Judge. You
okay. You too. Thank you, sir. Bye. Great. Good job. Just keep at it. Okay. So let's set it 30 days. I want to ride this through. You're so close to being through. All you got to do is see it to the end, and then everything great will happen for you here as well. Okay. All right. Good job. All right. Good morning, sir.
Thank you for seeing me, Judge.
Of course.
Coming before you, I don't really know what I'm doing. I just know that I came before you, and I was from out of state. You tried to help me, and I was kind of telling you that it was going to be dismissed anyway. I was here 9 days. They shipped me to Arkansas for 30 minutes. It was all done, set to be dismissed on the 9th. However, the police that stopped me had my car towed and put a card in my property. And so my car was sitting there the whole time. And so I had to find my way back to Houston. Since I've been having Uber back and forth and I couldn't get my car. It was $540, now it's $1,400. They said, look, you got 4 days, sir, and we're gonna auction off your car. But then they said, if the judge you went for, if he gives you an order, we will release your car, 0 balance. Again, Judge,
I can't give you an order to give you your car back. That would be me, in essence, ordering a company that does business to lose money to give you your car back because you don't want to pay to get the car back.
I don't want them to lose money. The thing is, my car was towed erroneously. I was at home. That's why I want to show you the police report. I was at home.
To file a complaint with the police, internal affairs. If you're telling me that if something was done illegally, immorally, or whatnot, you need to file paperwork with that appropriate agency. But I cannot order a private company to return something to you. I don't have that kind of jurisdiction.
What do they mean you get a judge's order and we release it?
Maybe a civil judge's order. I'm a criminal court judge. The only time I can ever order any kind of property return would be if it's confiscated by the state and they're holding it. So let's say you get arrested, you get pulled over, and you have a gun on you, right? They take your gun and they put it in the HPD property room, right? In that respect, under certain circumstances, I may be able to order them to return it because it's in the care, custody, and control of the state via HPD. Here, your car was towed by a private company and they're holding it, and it sucks. I get it that the bill has ballooned as much as it has. If you ever have a problem, you can always file a complaint with the bail bond, not the bail bond board, but there is a actual board for, there's a towing board too, isn't there?
I'm looking at it, yes.
It's a towing regulation.
There's
a request for a hearing, but I'm reading that it's got to be before the 14th day after the vehicle was removed, is that you have to submit a tow request. The forms are all here. It's 50.
And maybe the fact that you're in custody may toll. I don't know, but I'm not versed on that kind of. And I'm number one, number two. I'm not allowed to even give legal advice, but I don't know. But I can't order them to give you your car back. You know, that would literally be me telling them, "Hey, man, you know, just forget about all the money that you've made by holding the car. Just give the man his property back." I can't do that. I don't have the jurisdiction. Maybe a civil court under certain circumstances may order it back, but you'd have to file a lawsuit. You'd have to file some kind of paperwork.
I'm gonna pray for a miracle.
What I would do, perhaps, can you get on a payment plan with them and say, "Hey, look,
try that." They zero tolerance. I mean, honestly, I
and I have to understand, because imagine how many times they've probably gotten yanked. You know.
Yeah. I wish.
But theoretically, even if I were to give you a court order now, they'd have to. My guess would they would hire a lawyer, file a motion to quash my order, saying that, hey, he doesn't have the proper jurisdiction to do this, right? And then they may come after you for attorney's fees. My
manager's like, "Hey, man, if you give it to order, I'll release your car to you." He understood what happened. He said, "Man, just bring me something. I'll release it to you." I'm like, okay, I'm gonna go try.
And, you know, a lot of times they say stuff just to get you out, you know, but I can't. I'm sorry. But like I said, perhaps if you talk with the owner, you may be able to negotiate something with them. If you talk with if you talk with someone who has no power to negotiate, you always, if you talk to the right person, if you talk to them at the right time, you may get what you want. So don't go to them at 4:00 in the afternoon because they've been working, they're tired, they've probably dealt with a lot of people. All they want to do is go home, but go there first thing in the morning, try to get to the owner and say, "Hey, look, here's my circumstance. Here's the proof. Work with me. I want my car back." And I don't know, what do you think? Anything else, Freya?
No, I'll help him out with the tow lot information, and I also have got a copy of the HPD's agreement with private tow lots, so that maybe that can help him out.
Thank you, I appreciate it.
Yeah, I'm sorry. But, you never know. You know, it doesn't hurt to try. Just keep trying it. Look.
Yes. Thank you.
Okay. You're on bond for this DWI. You've been on bond since 2019, and now you've picked up a couple felonies out of state. I don't want you to talk about the case. My only concern is while you're on bond in this case, you're supposed to behave yourself. You're not supposed to pick up any new cases, and you picked up a couple felonies out of another state. Are we supposed to reward you for picking up new cases? What else has he done, Ms. Ziegler, since 2019? 2 cases, 1 case?
I believe it was just 1 case from October.
Why should I not revoke his bond and put him in jail now? He's on bond for this case. He's been on bond and he now picked up a felony in another state.
And I do understand that, Your Honor. I think that just in the interest of justice, I think that given the facts, and obviously we're not here to discuss what's going on in Louisiana. Are you representing him in Louisiana?
I'm
not. No, Your Honor, I'm not representing him in Louisiana, but obviously I'm in contact with counsel there. I think without getting into the details of that, Your Honor, I think it's an extraordinarily interesting law that they have, or laws that they have in Louisiana, where what we would consider as a technical civil dispute somehow gets transformed into a criminal matter in Louisiana. Obviously, the French civil law, I don't even attempt to try to understand those rules, but it is more of a civil dispute more than some type of fraud that was taking place in this situation. I think we're very optimistic that that's going to get resolved. Obviously, I've just been on this matter, Your Honor, focusing in on the DWI matter, Your Honor. Yes, it was a crash, but the facts as set forth in the incident report, Your Honor, he did not collide with another vehicle. He didn't hit a pole. He didn't hit a tree. Instead, based upon the report, he swerved to avoid another car coming out of a private driveway. So to avoid from hitting that vehicle, he swerved, hit a curb, which resulted in blowing out the tire on his vehicle. The car had other people in the car, and obviously that creates some issues, as Your Honor could imagine. But this was not a DWI case where he's driving down the road 60 miles an hour and crashes into someone or anything in that realm, Your Honor. For those reasons, I think in the interest of justice, having him to go to jail, not that that's what's on the table right now, but having
it is on the table now because he picked up a felony case while he's on bond for a case, right? He's been MIA for 5 years, and now you want some kind of in the interest of justice. The interest of justice is that we protect our county. You're on bond for this case. You've been on bond for 5 years. You've been gone. Now you pick up a felony case. Are we supposed to pat you on the back? No, I'm revoking your bond. I'm taking you into custody. What are we supposed to do? You know, you can't just be gone and then you pick up a felony case in another state. I mean, what are we supposed to do? You know, really. But you have to understand that actions have consequences, right? You're an adult. Your failure to act, your failure to come, you're picking up a new case. Now, I know that you say it's a civil dispute, but they found enough probable cause and a grand jury indicted you. That's usually between 9 to 12 people that sit, have completely neutral and detached, sit, listen to facts and determine, hey, we think this person may have committed a felony offense.
Original arrest warrant, and it's still, the DA still hasn't accepted charges.
And Your Honor, again, not getting into the details, and it's not, we're not here to try to resolve the Louisiana.
I get it, but
I'm sorry.
Go ahead.
No, Your Honor, I'm just, let me suggest it, Your Honor. What happens in Louisiana is this. There is a civil dispute between the parties, what we would call a civil dispute. And as a result, in Texas, what we would do in the event if a contractor or subcontractor is not paid, we place a lien on someone's property. In Louisiana, if that same transaction happens, the homeowner, now obviously there would be consequences, and maybe consequences for that homeowner, can call the DA and say, no, this guy ripped me off. Notwithstanding the fact they owe him money, this guy ripped me off. And if the DA there,
because I've had 2 people that have done that to me.
Well, Your Honor, over there, Your Honor, over there, that it turns into a criminal matter. So again, we think it's going to get wiped away. I know we are this close to getting this matter resolved. And I think in all respect to the court, all respect to the bench, Your Honor, not being here for 5 years is a major issue. This matter should have been resolved a long time ago. Had I been brought in 6 months ago, it would have been resolved 6 months ago, Your Honor. We're just asking that, one, if there could be a level of grace and mercy extended to Mr. Williams at this today, I think we could get the matter resolved today, Your Honor. Obviously, I haven't had an opportunity to look at the medical records. I haven't had more than 30 minutes to even examine the record.
And you know, I'm sorry that you're being placed into this precarious position now. And the facts are what they are, right? If we could make our own facts, we would all win. But at times, the bill comes due. That is today. But if you think that you can just continue to get away, jump 5 years, come back, and while you're out there, you pick up a felony case as well, I can't because I would be telling you that that behavior is okay, and it's not. If you guys are able to, work something out, by all means, I'm okay with that. But I can't in good conscience when he's been gone for 5 years. He picked up a felony, whether it's in Abu Dhabi, whether it's in Alabama, Oklahoma, he's hopscotching states, but he goes with you. If you want to work something out, I'm happy to whatever you guys want to do, but it's only fair, it really. But like I said, if you guys work something out, I'm happy to entertain whatever you guys want to do. But you guys talk. Don't
understand.
Not here. He's going to take him back. I'm going to let you guys talk, see what you want to do. I'm all ears. I'm always open to anything else. But the bill comes due. All right. Take your time. There's no rush. I'm not going to continue to play this game with you. Mr. Castro, I'm not doing this again. Look at me. I have people that continue to come back over and over and over, and I want you to look at me, because this is going to be a life-changing moment for you right now. They keep coming back. They keep pleading guilty. They keep coming back. They keep pleading guilty. And it's a revolving door. The door stops today. Do you understand? If you are unable to not pick up cases, then we are going to delve deep next time as to why it continues to happen. If that means putting you in a rehab facility, in a dual diagnosis residential facility for figuring out mentally why these things keep happening, then so be it. The door stops today.
Yes, sir.
Do you understand, Mr. Castro? I know you well. And in the last 2 to 3 years, we're working at least. Since you and I have been together, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 stops today. If you are unable to exercise self-control, we are going to dance a lot together next time. Do you hear me?
Yes, sir. Yes, sir.
Hear me loud and hear me clear, Mr. Castro, because I'm not doing this again.
Yes, sir.
We will have issues next time. Do you understand?
Yes, sir. I do. Yes.
You now stand charged with theft Hey, how many is this anyways? Is the next one a felony regardless?
I don't believe so, Judge, actually.
Judge.
You run an NCIC for me, please, Morgan. Let's take a look to see. Because I want to advise him properly as to, you need to understand that every time you plead guilty to an offense, it goes on your record. And when you pick up a certain type of offense consecutively and times, they can put it together and they can file a felony case on you, and you're looking at years instead of days. You now stand charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. They've offered you 6 days in jail credit for the 2. Any prior thefts, Morgan?
No, Judge, I'm not seeing any.
You were giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Mr. Castro, I want the best thing for you, but it continues to happen. So somehow we're not getting through to you. And we need to get through to you so that you understand it's not okay to continue to pick up criminal cases. And in the few short years you and I have been together, we're now working 12 cases. This is not acceptable. What do we need to do to get it to stop?
Yes. But yes, I'm completely capable of these, and because it is so highly agreeable. So I'm on top of it myself as much as I would be able to. This place, it is interestingly confusing, but yes.
Well, let me tell you something. I have a couple people in here that have continued to come back. And what we have done is now have them in facilities trying to figure out why they cannot stop picking up criminal cases. I'm telling you, I've got probably about 4 or 5 individuals that have kept with me. You now are on my list. So heed this warning.
Yes.
Do you understand, Mr. Castro? How do you plead to the offense of theft? Guilty or not guilty?
Guilty, sir.
And we'll find you guilty. I will sentence you to the agreement. Good luck to you, sir. All right, Josh. All right, Mr. McCollum, good morning, sir. Number 1, don't email me. That's not a good thing, man. Really, because I'm supposed to be neutral, detached. So I don't know what happens until if it goes to trial. So just, it's okay. But just from now on, all right. So you now stand charged. You picked up a terroristic threat of a family or a household member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. I don't know what happened in this case. I'm just now seeing it for the first time. All I know is that you're on bond for this case, for another case, and now you picked up a new one. So let's go forward and.
Officers were dispatched to a residence in Harris County, Texas. Complaining witness showed officers text messages ranging from May 2024 to November 2024, where the defendant sent her photos of guns and threatened to shoot the complaining witness and their child. Defendant also stated he would shoot up her house and hoped that he would hit her and the child.
When is the statement that he was going to shoot up the house? Was that from May and that he's just investigating this? Because that's not a terroristic threat. But if it was an active thing where he was.
Well, it looks like the offense. So per the offense report, the actual offense took place on November 8th.
Okay.
But I believe that she showed them old text messages.
Okay, so when was that statement that I'm going to shoot up the house and yada, yada, yada? Sure, take your time.
And Judge, while they're looking, it's not alleged when the statement was. and not only that, it's not reported till 3 days later. Furthermore, in the reviewing the text messages that have been submitted, there's not a single text message that has that specific threat in it.
Well, I don't know. I mean, it's the state's burden to show, I don't know, but terroristic threat has to be an immediate fear of harm.
So I don't see an actual date in the offense report. I personally have not reviewed the text messages in this case, Judge. I don't see a date of the actual threat.
That's not a good thing. I mean, who knows when that statement was made? Could have been made 2 years ago. Could have been made yesterday. Yeah, I agree with you, man. I mean, if you don't have anything else, then that's it. Okay, I'm going to find no probable cause. Mr. McCollum, we're not asking much, man. We want our streets to be safe. I'm going to do everything in my power to protect the streets, right? If I find that you're a problem, if they call back and it continues to happen, it's not going to go well. Life is way too short to live in a 6x9 box. There are a lot of great people in life. There's a lot of bad people in life. And if you have a relationship with a so-called person that brings out the worst in you, then don't have a relationship with this person. There's a gajillion and one fish in the sea. It's not worth it to have someone rap you so bad that you make and say things that make you go to jail. It's not worth it. Do you understand? Now, don't have contact with this person because it's just not going to end well. All right? All right. So I'm going to continue bond. I'm not going to revoke your bond on this case now because I'm finding no probable cause, but just behave. It's not hard. Be nice. All right. Okay. For sure.
Morning, George. He speaks both English and Spanish, Judge, but he says he may feel a little more comfortable in Spanish.
I don't know if it's going to be a good Mr. Martinez. I'm not happy with you. I asked you one thing. I have here that you're tampering with your device. Any alcohol detected?
No alcohol detected, Judge.
What do you know the?
Me?
But either. What?
So what he tells me in terms of the, I guess, potential tampering, he said was, the device was wet around his skin. So he used, in fact, he told me yesterday, he used a leaf blower to dry it off. That may have been one of the times it was tampering.
That wouldn't cause a tamper. Environmental factors like that don't cause something like that, and that would be such a short period of time. I have the durations of the hours on that little sticky note, and I can't remember them off the top of my head. But tampers are confirmed after 8 hours with no alcohol detected, so therefore a leaf blower wouldn't. If anything, it would show a spike in tamper, but nothing to cause a tamper.
So what we have here and what I have here, your first tamper was on October 28th, and it was in an 11-hour tamper. So more than likely, what we find is that people put things in between the scram device and their ankle to subvert the machine. Your second violation that we have is on November 11th at 3 in the morning, and that one is a 9-hour tamper. How does that happen?
So, Judge, the only thing I have is the violation report. I don't have any other documentation from you guys showing exactly well.
The problem is that there's only.
But in terms of saying that it was for 11 hours.
I have the scram report, counsel. I can send it over to you.
But, and if you want to take time to look at it, but what we find, there's no cameras. So it's impossible to really look at what they're exactly doing. But all we know is that they're breaking the continual skin and device contact. And how they're doing that, I wouldn't know. Only he knows. But all we know is that the tamper is for a duration because the contact is lost somehow. Piece of paper, could be that they're using a sock, however it may be. But all we know, it's for a certain duration and that it's a tamper and it remains constant for that entire period. So the machine is not able to test his leg.
Okay, yeah.
So I'm happy to give you the device. You will stay with me now and take
I'd
a
like
look
to look
and tell
at
me
it and
what
talk
you
about
think.
Yes, exactly what.
I mean, I'm not letting him go.
I understand.
Okay.
Okay, so.
So
I'll get that and then
we'll give you the info now. I'm taking you into custody right now. I'll let you talk. I don't want him to go outside.
I understand. I understand.
Yeah, but I'll give you more than enough time to talk.
Sure, okay. Okay, we'll talk afterwards.
Yep.
All right. Sure, MAA.
Good morning. I wanted to bring you out because there's things I would like to address with you. I don't know if at the time we ordered her not to consume alcohol or illegal drugs. Let me see. One of the things that I ordered you to do was not have any contact with a Ronnie Boo Slyman.
Yeah.
And I see now that you have picked up a continuous family violence felony case. You don't have to say anything. I'm just letting you know what's happening. Now, we asked you not to do several things, and you have now violated several conditions of our bond. One of those being, number one, we ordered you not to have any contact with this person, and allegedly you've picked up now a felony assault against this person. You picked up a felony violation of a bond condition or protective order, and you also have picked up a felony assault against a peace officer. Because of this, I'm going to now revoke the bond here that you have here, and I'm going to raise it up. I'm not going to give you a PR bond when you continue to violate conditions. I'm going to do everything in my power to protect my public at all costs. And I'm going to tell you now, there are certain people in this life, when they consume alcohol, they become funny people. They have fun, they laugh like little rainbows, gumdrops, gummy bears, and little bunnies jumping in the woods. And there are those, when they consume alcohol, they develop horns, they become the antithesis of what a person should be. And if alcohol has this kind of effect, don't use, because that may very well be the source of all these issues. I don't know, but I'm taking a stab.
Judge,
and I hope not.
But I may, Judge, just to let the court know, since she's been on bond conditions, she did voluntarily check herself into treatment for alcohol. So as the court knows, that the road to recovery is long and bumpy. She's in a difficult situation, being that she's originally from Mongolia. Is that right?
No, Kazakhstan.
Kazakhstan. I'm sorry, Kazakhstan. She had a pretty crazy story about getting here. This guy that the court told her to stay away from, is like one of her only connections, and he's also done some inducement to get her back over there. I understand that it was ordered for her to stay away from him, but it makes it difficult when you don't really have a lot of people to rely on, and then you have someone who's trying to basically get you to hang out with them, even though they know that it's been ordered that she shouldn't. But I just want to let the court know that she is taking steps to try to better herself and her situation. It's just she's in a difficult spot between the addiction and lack of resources.
Even if that's the case, if you know that alcohol has this effect and it brings out the worst, then don't. You already have an open case. And you know, if you have no one to rely on in this world, if you go to jail, they're not going to bond you out, then you have to think of these things when you're out there. Because sometimes, you may have but 1/10 of a second to think, oh God, if I do this, what's going to happen? If I say this, what's going to happen? Now, where are we?
Can I say something?
Well, it's now, anything you tell me, it's going to go in this ear and it's going to go out that ear, because I know if I let you out, you're still going to do whatever you want to do. You don't care what we say. That's the problem. And when you come here and when we talk to you initially, we try to tell you, look, this is how we expect you to act. This is what we expect you to do. And when you do, and when you show up to court, and when you talk with Hunter, good things happen. Now, I'm telling you this for the future because I don't know what's going to happen from here on out. All I know is that you have very serious cases upstairs. And in the future, going forward, whatever may happen, whether it's a probation, whether it's this, think before you act. And if the source and the root of all evil is, no matter how bad the addiction is, if you don't, it only gets worse. It never gets better. And the older you get, the more difficult life becomes. You get older, bigger, fatter, you lose hair. Life doesn't get easier. And when you get more of this, so I hope that you take the help that is offered now, because we're going to offer you help and we want the best to come out of you, right? We want the best for you. But you can't continue like this. So now, like I told Hunter, I am going to revoke your bond. I'm going to raise it up to 5,001. We'll come back in a couple weeks and see how we go forward. But I can't give you a PR bond when you pick up 3 felonies.
Judge, may I make argument for bond amount?
Sure.
She currently has bond amounts on her felonies that she can't afford. She's indigent. That's evidenced by the fact that I was appointed to her, and also given a little bit of her background, she's not only indigent, but she's has a lack of resources otherwise. I would ask the court to consider $250 bond.
Gotta love you, Hunter. Gotta love you.
Just taking
the bond's at $2,500 now, so that would mean lowering the bond. I'm going to set it at 5,001. We'll go forward. It looks like your felony case is set for February. You will go to felony court in February. Hopefully, you guys can wrap this up and try to get everything quick so you don't just sit there and linger.
Just ask for a speedy trial date on this case.
Absolutely. I have to give them at least 30 days for them to get all their stuff in preparation. Is it your case? Is it
It's actually
Conrad's? Yeah. Okay. I guess let's do this. Is he here? You want to talk to him?
Not by, but I can give him a call, maybe.
No, but I want to give him or if you can give him a heads up that's where we're at. I guess let's set it for early next week. Is discovery complete in the case? Wait till at least we have some discovery first.
I think it's all complete.
I think we're still waiting on body cam. Let me see there. Yeah, it looks like this looks like body cam was re-requested.
We don't even have body cam. Let's do this. Let's set it for next week, like late next week. See if we can get the body cam. If you can get it, and then we can get also Conrad to come approach, and then we can set it at that time if you want. Yeah?
Good, Judge.
All right. We wish you the best of luck, man. Take care. Mr. Williams, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 9 days in jail with credit for the 19 days that you've done. I want you to understand that this behavior is just unacceptable. you know, and I'm serious when I mean that here, we're about accountability. And if I don't hold you accountable, I'm telling you it's okay and that you can just continue to run amok and just and railroad. And it's not. We mean business. We're here to not only protect the community, but to teach you a lesson so that you understand that it can't continue, right? I don't know what happened over there. I don't need, but when you're on bond, you can't pick up a felony case and there are consequences. And I hope that you get it, right? The other thing that you need to get also now is that this will reflect as a conviction on your record. If you're ever in a car, I don't care where you are, I don't care what state you're in, you get pulled over and you have a smell of anything funky, they're going to probably take you in. They see that you have a prior DWI, if it walks like a duck and it talks like a duck. So if I were you, I would never, ever get into a car, even if you've had a sip of alcohol, a toke off of a joint, you smell anything funky, I'm telling you, you're going to go down. And what we're doing today, from now on, you're facing a minimum of 30 days in jail. So like I'm saying, I'm doing this, believe it or not, to help you because we want to see the best in you. We want the best from you. Be better, do better. You know, you're giving up the right to a trial, right to compel witnesses, testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you accept this agreement. You can never change this or undo this. It will go on your record. It will be there forever. I have to suspend your license. I am going to suspend it for 180 days. There is also a mandatory suspension, a DPS surcharge. I will waive that for you now. But I want you to understand that if you come back a second offense, you're looking at a minimum of $6,000 in fines and fees, not to mention another court cost of around $600 to $700. So if you pick up another DWI, not only is a minimum 30 days, but you're looking at probably around $7,000 in fines and fees. Just one button on this phone, $30, wherever you want to go in this, don't matter where you want to go. That's what you need to do. How do you plead to the offense? Guilty or not guilty? I'll find you guilty. I will sentence you to it. You're going to walk out of here. You're not going to owe anything, but don't come back. All right. Thank you, counsel. All right, guys. Good luck. Yes, sir. Thanks. Yeah.